And today on the show, I'm delighted to be joined by Daniel Glad. Daniel is a director of the Procurement Collusion Strike Force at the US Department of Justice. Now, the Procurement Collusion Strike Force leads a coordinated national response to combat antitrust crimes and related schemes in government procurement at all levels of government. So that's federal, state, and local here in the US. In today's podcast, we're going to discuss how the US Department of Justice is rooting out criminal acts in public sector procurement. And so, Daniel, it's an honor for me to welcome you to Art of Procurement today. Thanks for joining me.
Well, thank you for having me. I'm really excited to have this conversation.
Yeah, well, the first question that we always ask for guests on Art of Procurement is, did you find procurement or did procurement find you? I think from your perspective, a little different journey, a little different perspective, but I'd love to know how you kind of got involved in the world of procurement.
So I am a lawyer by education, training, and experience. And more specifically, I'm a federal prosecutor, and that's the role I've had for quite some time. I'm not sure if I found procurement or if it found me. My first job in government, so I spent several years in private practice, but my first job in government was with the City of Chicago Office of Inspector General, where I was Assistant Inspector General. And that's an office that is dedicated to rooting out fraud, waste, and abuse in city government. If you know anything about my hometown, it's
Mhm.
a governor-rich environment. And so many of our cases there involved companies, contractors, vendors, and people doing business with the city and tilting the playing board in their favor at the expense of the taxpayers. And I really just found those cases to be really righteous and fascinating. And when I came to the Department of Justice after being with the City of Chicago, OIG, there again, those were the cases I enjoyed most.
Mhm.
I thought the facts were most interesting. They allowed me to do the kind of work that I came to DOJ to do, to work with federal agents and try to essentially right wrongs.
Yeah.
And the kind of schemes my team and I'll go after really do impact everyone who is a taxpayer or
Mhm.
the user of public services. And so it's something that has been near and dear to my heart for quite some time.
How complex are those cases? I mean, I can imagine that, they can be, there's a lot of investigative work that goes behind a lot of those cases.
Sure, there is an absolute ton of work, and all of these cases have some degree of complexity, but some are more complex than others.
Yeah.
If only by the size of the scheme and the scope. The the snow plowing cartel in Kalamazoo is going to be less complex than a nationwide or
Right.
global scheme.
Yeah.
But it's still a white collar offense. So it's
Yeah.
going to be document intensive. The So much of the work is going to be spent proving what happened, who was involved, and looking at documents and other evidence from a variety of sources. It's not the same as catching a bank robber,
Right.
which those are cases I worked way
Yep.
back in the day, and they had their complexities too. But really, that's sort of there's an immediate outcry here. You're really trying to piece together, which is it's part of the fun.
Yeah.
It's like working with other lawyers, working with federal agents to put together a puzzle.
Yeah. Could you talk a little bit more about your role specifically and then the types of organizations that you work with?
Sure. I am the director of the Collusion Strike Force, or the PCSF, or the Strike Force. Procurement Collusion Strike Force is absolutely a mouthful. What we are is we are an interagency group started in 2019.
Mhm.
I think as you put it at the beginning of the show notes or the beginning of the show, we stand ready to detect, deter, investigate, and prosecute antitrust crimes and other related schemes that go after that victimize government spending on goods and services. So I'm the director. So I'm in charge of this overall group. But the real work is happening with line prosecutors and line agents in 25 different judicial districts in 25 cities around the country. And we partnered there with the individual U.S. attorney's offices in these 25 cities, and we work with our 12 national law enforcement partners. So that's the FBI and 11 federal offices of inspector general. Most of my work involves overall strategy, building external relationships, providing guidance and support for the district teams and the individual case teams, and then reviewing and approving charges when they come up for that approval. In a lot of ways, I do a lot of work that builds, you know, lays the ground for all the people who do the real
Yeah.
interesting case work, to allow them to do what they do, and eventually stand up in court and say, "Good morning, Your Honor," for the United States.
Yeah.
I see my role as trying to kind of help create the conditions for those people across the country to prosper.
Now, are there typical examples of conduct, that you typically see that, you look at and say that's something that subverts the competitive bidding process and therefore is something that we want to take an interest in?
Yes. So within the Department of Justice, it's a very large organization. It's organized into different groups. I'm in something called the Antitrust Division. So our North Star is the Sherman Act.
Yeah.
A law passed by Congress in 1890 that criminalizes certain kinds of agreements as being so anti-competitive and so plainly wrongful that they are criminal violations.
Yeah.
So the classic examples are going to be things like bid rigging or price fixing or market allocation or a criminal conspiracy to monopolize. And at the Antitrust Division, the Sherman Act is always going to be our North Star. But we will use any tool in our statutory toolbox, other parts of the US code, to combat this conduct. So there are times where it's not bid rigging because you don't have two or more competitors reaching an agreement, but instead it's just fraud upon the United States. So it's a violation of 18 U.S.C. 371, or it's a wire fraud or a mail fraud because it's one competitor through the use of shell or fake corporations creating the appearance of competition and lobbing in these fake bids, either using the wires or using the mail. Sometimes there are bribes paid to government insiders to help kick off a bid rigging conspiracy or another fraudulent conspiracy. So we use a lot of these tools, but what it essentially is it's conduct that robs the government, and that's of all levels, that was state or federal, robs the government of the benefit of competition. Competition is the free, open competition. That is sort of the Magna Carta of the American economic system, and robbing the government of the benefits of that is inherently wrong.
Do you find is there an obvious line that over which conduct becomes criminal, or it's really you're looking at the merits of every single case and all the nuances of every single case and trying to piece that together?
So my team and I, we are criminal prosecutors and we work with federal agents. We are only investigating and prosecuting criminal offenses. So in the antitrust world, through 135 years of case law and statutory interpretation, there's a very narrow group of offenses or narrow group of agreements that constitute criminal offenses. It's rigging bids, fixing prices, allocating markets or customers or products or outputs, and then criminal monopolization. We are not looking at civil claims for damages. I don't do, for example, False Claims Act work. Those are civil offenses, or those are civil suits for money damages.
Yeah.
I do, however, work closely with the parts of the DOJ that do that work, and I'm happy to refer matters to, for example, my colleagues in the Civil Division Fraud section, or civil AUSAs in offices around the country to, protect the United States, because ultimately we're lawyers and we have a client. Our client is the United States,
Yeah.
and that's what we're looking to do. And if the USA has been ripped off, part of our mandate is making our client whole.
Now, how do cases reach you for investigation? Is it, they're kind of coming to you, or you're kind of proactively investigating and finding cases kind of in that way too?
So you asked me an or question. I'm going to answer with yes.
Yeah.
It's both and more than that. So, um, we are public servants, and we have a public facing website and tip line. So we receive complaints from the public,
Yeah.
who will see something and say something. We have cases that are brought to us by law enforcement officers of various agencies, procurement officers, contracting officer representatives will bring us cases. And a lot of times those folks don't know exactly what they have, but they know that something is wrong. Humans are pattern recognition machines, and it's possible that while they can't articulate what it is they've spotted something and know something is wrong. We have a leniency program in the antitrust division whereby guilty conspirators can come in, and if they cooperate fully and make a full confession, they can receive some benefit. We also have a new whistleblower program that I'd love to talk about, where whistleblowers can bring information to us and may be eligible for compensation. And then finally, yes, we are proactive. And I'm not going to, uh, like Colonel Sanders, I'm not going to give away all 12 secret herbs and spices, because I don't want to make better criminals through our conversation today.
Yeah.
But we are proactive with using data analytics.
Yeah.
So that's data the government already collects by way of being in the market to buy goods and services. We examine other market data. We take other steps, often with a tipper lead, to gather evidence. To include, we had a case that was set for trial this year, and the defendants all pleaded guilty. But one of the things we'll use are wiretaps. We call it a Title III wiretap intercept, and we were listening in, just like in the TV show The Wire, as the conspirators were talking in real time, not thinking anyone was listening. And that can be very effective at gathering evidence and also sort of jump-starting cases, because there's nothing more compelling than hearing the offenders say it in their own words.
Yeah, but I imagine that technology is a huge benefit for discovery and for the document trail that you talked about before, that is often the pillar of a lot of these cases.
That's true. Although communications have changed immeasurably since my career started. I've been a lawyer for about 20 years now. And these crimes that we look at are often occurring in a company, a corporation, or a company context. When I first started my career, most of the communications, legitimate and criminal, were occurring on company communications media. Your company email on your company phone. And one thing that has absolutely happened in the past 2 decades is that people are becoming more and more comfortable being multi-channel communicators. And anyone younger than I is native at that. They had an email address when they were 8 years old, and they got their first cell phone when they were 12. And they've been using apps like WhatsApp and Signal for a very long time. And so typically people younger than I'm not particularly young anymore, but they are not committing their crimes on the company device. That represents a challenge. It represents a challenge for the companies who are committed to compliance and try to catch these things through audits. And it's a challenge for the government, because we can't just send an FBI agent to the company to take the email server. But it's also an opportunity because people are so much more communicative.
Yeah. There's a paper trail.
There's a paper trail. I mean, think about what's the first thing you do in the morning?
You check your phone.
You check your phone.
Yeah.
Maybe fire off a response to a text or something.
Yeah.
Last thing you do before you go to bed.
Same again, sadly. I wish it wasn't true.
Yeah, me too. But that is very much the case. And so it leaves all these traces, all these pieces of evidence. So it is a challenge, but it's also an opportunity. And these cases are made with the documents. Documents alone are not going to be enough to convince a jury, witness, but it is absolutely the case that we are looking at all of that.
How challenging is it to help juries understand these cases? Because as we talked at the beginning, I mean, I'm sure there are some pretty open and shut based on just stupid behavior that are relatively straightforward. And then there are some that are extremely complex that need a lot of unraveling. And, do you have challenges in convincing or helping a jury to understand kind of the nuances of some of these cases?
It's a good question. The jury system is such an important part of our overall system as a democratic republic. And it's this really important check on government power. Because what my colleagues and I are doing when it comes to individuals is we are exercising the monopoly on force that we give the state. Now, like this turned into a political science 101 class, but the state has monopoly on this particular power, the deprivation of liberty.
Yeah.
So the jury is a crucial part of that. And we know that in criminal antitrust. So it remains a helpful touch point at every step of our work. My colleagues and I were, how do you explain this to 12 people? How can you help them understand why this matters? How do we streamline? How do we make the main thing the main thing?
Yeah.
Which is different than when you're putting a case to a judge who is, has lifetime tenure, generally incredibly learned in the law.
Yeah.
Although every judge will tell you, I'm actually a generalist. I handle every kind of case. But to get back to the core of your question, does it present challenges? Sure, it does. But in a lot of ways, it's probably the most important challenge my colleagues and I have is getting members of the jury to understand why what the government thinks happened. And, sort of, this isn't necessarily an element of the offense, but why it matters.
Yeah.
And I think it presents a challenge, but I think it's right that it presents a challenge.
Yeah. There's the burden requires you to be as definitive in the evidence that you're able to provide to convince a jury that there's no question of guilt or otherwise.
That's why our burden is beyond a reasonable doubt. It's serious and it's important, and we do take it seriously. We embrace that burden, and I wouldn't want the system where it wasn't difficult.
Yeah,
I think that's really like our ordered liberty that we have in the United States. It's really, really important.
Yeah.
Juries don't always agree with us. We have had acquittals in some of our cases. I still believe those cases were righteous, and I think what the lesson we learned there from those is what can we do differently to streamline, make a better trial presentation. Every trial lawyer will tell you learn more from your losses than your victories, and that is very true.
As such in business as well.
Probably true.
When let's see, when you look at the burden of proof that we talked about, like what level of intent is required to be guilty of a procurement related crime? Is lack of a legal knowledge a defense? Or kind of what perspective do you take on that?
So the knowledge requirement, or the word lawyers use, is the Latin word scienter. And the trick about being a lawyer is when you use Latin, you get to charge double per word, right?
Nobody else knows what the meaning is.
Honestly, sometimes we don't either. The level, the intent requirement is going to be specific to the charged offense. But at a general, and I think what you're getting at is a general level, it's a knowing requirement. Did you know what you were doing, and did you intend to do it?
Yeah.
Some crimes have what's called a willfulness center requirement that requires something more. But these aren't cases of accidents.
Yeah.
Like you had to know that you were going to agree to rig bids or fix prices. You had to know what that was. Now, what you don't have to know, it's not an element of defense. You don't have to know it was illegal.
Mm-hmm.
Ignorance is not an excuse. It's not a defense. Ignorance of the law. It
Yeah.
never is. We have lots of conversations with defense attorneys on that very topic, and we will hear a lot about that. But for every time my colleagues and I hear they didn't know it was illegal, we often have many times over examples of maybe they couldn't cite chapter and verse why it was illegal, but they took steps to hide what they were doing because they knew what was wrong. Sometimes that's speaking in code.
Yeah.
Sometimes that's sending emails that say delete after reading or keep confidential. Sometimes it's obscuring their locations. I remember I've had cases where people would, they wouldn't say where they were going, but they would use the name of a baseball team
Mm-hmm.
to sort of as code for where they were going. There are lots of things that sort of indicate some what we call consciousness of guilt,
Yeah.
which is usually going back to your question about the jury, is something that juries react well to because even though you didn't have to know it was a crime and it's not a defense, I think that's part of the jury system is they're not looking to ring people up on a mere technicality.
Yeah.
And honestly, neither are we.
No.
We try to go after the most serious defenses to address this conduct because it is such an effective deterrent, in particular with individuals. Now, my team and I, we charge both companies and individuals, but for individuals, these are criminal offenses. These are felonies.
Yeah.
And they can result in a prison sentence of, if it's a Sherman Act offense, 10 years in the Bureau of Prisons.
Mm-hmm. And that's, I was going to actually ask about penalties. So that's kind of typical for the cases that you bring, that is ultimately the punishment for those that are found guilty.
Well, the statutory maximum and the punishment imposed are two different things, and the sentence is ultimately determined by a judge who considers a lot of different factors, including the sentencing guidelines and other factors that are spelled out in the statute that we kind of shorthand as 3553A. The sentences do vary within the past couple of days. We had someone sentenced to 6 months in the Bureau of Prisons for the offense conduct. Last year, or maybe the year before, we had someone get nearly 7 years. And so it will depend on a lot of different factors.
Yeah.
But the prospect of incarceration is something that we believe really can change behavior because bid rigging is not a crime of passion.
Yeah.
No one fixes prices in hot blood.
No.
It's a calculus.
Yeah. To make money.
It has to do with like probability of detection, certainty of punishment. And so that deterrent, the deterrent effect of incarceration is very significant. And that's why we are focusing so much on it, especially as of late.
Do you find that there's any categories of suppliers or spend that are particularly prone to fraud?
There are. The first thing I think about is government spending on goods and services, just generally. The government is a repeat at all levels, local, state, federal, is a repeated victim. And a lot of times folks ask, why is that? And there are a number of reasons, but one of the key reasons is that the government is a major market actor.
Mm-hmm.
Government is a huge buyer of goods and services. Another way I like to think about it, there's this famous quote from a 1930s bank robber. He's like being walked into the courtroom, a reporter shouted out, "Hey, Philip, why did you rob the banks?" Mm-hmm. And the bank response was, "Well, that's where the money is."
Yeah. Yeah.
There's some truth to that.
Yeah.
But there are some other reasons that the government is especially vulnerable. And these are market factors that exist and persist, whether we're talking about the government or in the private sector. Um, there are certain hallmarks where this conduct pops up.
Mhm.
Um, One is if there are just few players,
Yeah.
few sellers. Um, and in part, that's because for I think the simple truth that it's easier to keep a secret
Mhm.
among three than it is among 30.
Yeah.
It's just easier. And that's what we're talking about. We're talking about secret agreements.
Yeah, collusion for, to allow somebody to have a market and not compete against them, and those kind of things, effectively creating a monopolistic situation.
Correct. Another factor are where there are barriers to entry. And in the
Yeah. Yeah.
government sector, there are plenty of barriers to entry. One is you have to generally be qualified. It is more complicated. And so it's often more expensive to sell
Yeah.
to the government than it is to sell to the private sector. That barrier to entry also leads to fewer players.
Mhm.
A lot of times the government's purchasing items that a barrier to entry would be the capital cost.
Yeah.
For example, it is not cheap to set up an asphalt plant.
Mhm.
I know that because I worked for, many, many years ago, I worked on in an asphalt company.
Yeah.
You got to buy real estate. You got to buy a whole bunch of heavy equipment. You've got to get permits and licenses. Um, Another area where the market factor we see when there are regular, scheduled, and predictable purchases, it makes it
Mhm.
easier for a conspiracy to arise and persist. What's more regular or scheduled than like mainline government spending?
Right. Yeah, it's just those annual drum of invoices that get paid without anybody really looking too deeply into them, and, that adds up over time.
On the other hand, another factor that can lead to this are emergency and purchases and rush drops. And who's sort of more, sort of in the midst of emergency and rush than when the government's trying to provide particular services,
Yeah.
whether it was certain services we all were seeing the government try to provide in March of 2020
Mhm.
or 20 years ago during Hurricane Katrina.
Yeah.
When,
Feel related.
when the emergencies happen, the
Yeah.
guardrails go down.
Yeah.
Frankly, as they probably should, because you're trying to protect the health and safety in lives of your people. But there are those, and we had cases going back to Hurricane Katrina. We had those who sort of saw a disaster and saw this human suffering and decided, well, there's a way I can really kind of like I got an angle.
Yeah, it's an opportunity for a bad actor because they know that the level of due diligence isn't what it would be going through a traditional procurement process, for example.
Precisely, precisely. Right? Though, and so those are areas where um, that that spend is particularly vulnerable to
Mhm.
this kind of conduct. And overall, it costs just so much money. There's this really interesting study done by an international non-governmental organization called the OECD, and they did an analysis and determined that for all governments worldwide, roughly 20% is lost
Wow.
to bid rigging, price fixing, and other forms of collusion at the front end.
Yeah.
20%. And I have no reason, based on my experience and the collective experience of all people here, to think that the US is an outlier
Mhm.
from that number. And in fact, there may be parts of the US where the number's slightly higher. This kind of collusion tax
Yeah.
that bad actors are imposing, you know, perhaps my hometown of Chicago might be paying even more than that
Mhm.
20%. So when you think about how much the government is spending on goods and services, these numbers they add up very quickly.
Big number. Right.
It's almost incomprehensible.
Yeah.
And it really, I mean, it affects the economy really large,
Yeah.
which is why we exist
Yeah.
and why we're doing what we're doing, trying to collaborate across these different agencies to get after these issues.
So in a moment, I want to talk about the whistleblower program that you've put into place. Before I do, I just wonder, for people who are listening, what are maybe some early warning signs, to look for that suggest that, as you talked about before, humans are, creatures of pattern recognition, and there's kind of you can kind of tell from the sniff test whether something is, above board or not. Do you see any common um, leading indicators that at least there's something that's happening to be concerned about?
Yes, there definitely are, but I should preface this by saying I'm going to talk about red flags.
Yeah.
And a red flag is just that. It is a stop, take a look a little deeper. What I'm about to tell you is not proof positive that a crime is afoot.
Yeah.
But a big one is sudden, if you're on the buy side,
Yeah.
sudden and identical shifts in pricing from all your suppliers.
Hmm.
Now, the innocent explanation is some input, the price of the commodity input went up. If you have
Still went up and everybody by 10% and everyone increased their prices by 10%.
yes, but if that didn't happen,
Yeah.
like the sudden, if you're on the buy side, I admit, and I'm not a procurement lawyer, I don't pretend to be a procurement lawyer. If you're on the buy side, you see that. I assume you're going to be asking questions, but maybe the answer is yes, the price is stupid.
Yeah.
But the answer could be, it looks the same, is if they've all, if the competitors have gotten together and decided we're going to increase prices all at the same time.
Yeah.
A red flag that is seems less innocent is if you are, again, on the buy side.
Yeah.
If you're getting stonewalled on your efforts to shop around.
Hmm.
If there are people who just aren't interested in even talking to you about the business, that would suggest there's some sort of allocation agreement where competitors have split up customers or territories or something else. It generally, sort of in our competitive system, with the profit motive, companies are going to want to do more business.
Yeah.
Another, and now we're getting into, this is a pretty big red flag. Certain tells or indicators you see on the buy side that competitors are working together. Identical phrasing in documents. A big tell would be identical typos. We have a number of cases, kind of classic cases where it's the same typo in two cover letters from purported competitors. They work together and we're just copy pasting. It can show up in the pricing. There are certain, you kind of have to build out the pattern, but if the prices are always a certain percent higher, always.
Yeah.
Or round numbers. If you're hearing comments, again, on the buy side, if you're hearing comments from your vendors, we have an arrangement with competitor X. Well, that now we're really kind of in the danger zone. And, I think it's harder if you're on the sell side.
Hmm.
I think it's harder for sell side folks to spot it. But one thing, if you're in the audit or compliance space, I'd be looking to see if I could figure out if there are massive shifts in pricing strategy or pricing outcomes after my sales force attended an industry conference.
Yeah.
Because at the industry conference, they can be very valuable, but they also present the opportunity to.
They're gathering spaces for people cross industry.
I don't want to chill conferences. I don't want people to not go to conferences or trade association meetings, but everyone needs to know that is a danger zone. You need to be very, very careful. And I think typically people at conferences, they tend to enjoy them. They tend to hit the hotel bar. And sometimes we've had cases that have started where the conspiracy started at a hotel bar or a trade association.
It's very interesting. I spent a lot of time as a buyer, but in the private sector. And so would come up against a lot of these monopolistic situations. And, the mindset is always, this is just this is a commercial difficulty from which I need to find a way to mitigate in some way, shape or form for the company that I worked for. You never really think about it as, I don't know, this is private sector versus public sector, but you don't look and think, I wonder if there's kind of criminal acts that are taking place. So I think it's interesting from a mindset perspective to look at when you're kind of seeing some of those red flags to question, is this just the commercial reality of what I'm trying to buy and the products and service I'm trying to buy versus when it goes deeper than that, and that there may be an opportunity that there are criminal acts that are taking place.
Yeah, I think that's right. I don't want I don't want you to walk away from this paranoid and looking for ghosts behind every tree,
Right.
because most, like in all things, most people are good and decent and law abiding and upstate.
Yeah.
But I do want you, and I want your listeners to be aware that this does happen.
Mhm.
Based on our work over decades, it happens in every part of the country, in every part of the economy.
Yeah.
So if you have just enough information to know what to look for, and to be not paranoid, but I think it's Ted
Just
Lasso.
mindful.
Yeah, mindful. I think the way Ted Lasso, there's this episode of Ted Lasso. I don't know if you watch that program.
As a Brit, anything that has,
Anything that has, as you call
football,
it, footing, and
then
yes,
I'm good.
but be curious.
Yeah.
I would encourage your listeners to be curious.
Yeah.
They don't have to be judgmental. Be curious.
Now we alluded to it earlier, but the first ever whistleblower reward initiative by the DOJ's antitrust division was announced recently in partnership with the US Postal Inspection Service and the US Postal Service Office of Inspector General. Exists for folks who have concerns and have had curiosities to report some of the concerns that they're seeing. I wonder if you could talk a little bit about what that program is.
Absolutely. This is a first of its kind program for us. We're really excited about it, and we think it fills an enforcement gap and kind of helps disrupt the space, which is important to us as enforcers. We're looking to disrupt criminal criminal conspiracies. It kind of, as you might say, Phil, it does what it says on the tin.
Yeah.
It offers monetary incentives of up to 30% of recovered criminal fines for people who provide original, credible information that leads to successful prosecutions. My boss, the Assistant Attorney General, she said, I really liked what she said. She said, if you're fixing prices or rigging bids, don't assume your scheme is safe. We'll find and prosecute you, and someone you know may get a reward for helping us do it.
Yeah.
Which is really a big part of, that's the reason we're doing it.
Yeah.
Dive into the details a bit. We need to get a criminal fine or penalty of at least $1 million. Those are fairly common. Our statutory maximum criminal fine for each corporate defendant is $100 million, but we can also go higher than that in certain circumstances. So we are frequently getting those kind of fines. We have to have a whistleblower has to report certain kinds of conduct, essentially the kind of conduct we've been talking about today. Violations of the Sherman Act, other federal offenses that target government procurement, or crimes that impact the process of the proceeding. So obstruction of justice, perjury, deletion of documents. One important part for people who are thinking they might be a whistleblower, there has to be a link to the post office. I mean, that's because that's where the statute that allows rewards is. So there must be, as we say, an identifiable impact on the United States Postal Service. But that is true. I want people to think broadly and just to take a step back. Remember that there's only one part of the U.S. federal government that touches every household in America 6 days a week, and it's the post office.
Yeah. The post office is basically a communication method.
Communications, even in 2025. So here are things that would constitute the postal link or the postal nexus. And we are looking at this broadly. Selling price fixed goods to the post office, of course.
Yeah.
Rigging bids for postal projects. Yes, absolutely. Using the mail in connection with your scheme or further into the conspiracy. Yes. So did they mail price fixed goods?
Yeah.
Did they send a rigged bid by mail?
Yeah.
Was an invoice that was the result of a criminal agreement sent through the mail, or remittances, so payments sent through the mail? This is in an exclusive list, but I want any potential whistleblowers out there to think really, really broadly. It's not just the sale of mail trucks or tires for mail trucks to the post office. It can be a lot of
any touch point with the U.S. mail service at all.
Someone I know really well who works for one of the postal law enforcement agencies would often say, "Did someone lick a stamp during the commission of the offense?" That would be enough, and it's a little tongue in cheek, but they do look really, really broadly. And we have worked with these agencies, the U.S. Postal Inspection Service and the Postal OIG, on a number of matters throughout the years. And it goes from healthcare to road building, infrastructure, automotive equipment, chemicals, school supplies, and of course, mail delivery. But they really are covering the gamut.
What would make somebody eligible for protection through the whistleblower program?
So well, there are two different things. The protection can occur as a result of a different act. What this provides is it provides money, it provides the incentive, which the disruption happens in which is why it's so important. So you have to come in. It's got to be voluntary.
Yeah.
You can't get a subpoena and then say, "Oh, I'm a whistleblower now, and I'd like some money, please."
I'm going to admit to everything that I've seen.
No, you have to come in voluntarily.
Yeah.
You also have to provide original information.
Yeah.
It can't be derived from a public source or prior filing or something the government already knows about and is investigating. And that has to be one of the enumerated offenses and have that postal link. Those are the primary eligibility criteria. It's also important. There are a couple of things that make people ineligible.
Yeah.
You can't be a whistleblower if you coerced others to participate in a scheme and now you're reporting it, hoping to get paid out for it. No, you can't be the leader or originator of the crime you're reporting. You're not going to get paid for that. If you're a law enforcement official, if you work for the post office, or if you're an attorney who got information because of your relationship with the client, and you can't trade on privileged information. We're not going to pay for that.
Now, we'll include this in the show notes for today's episode so people can go and follow a link. But if somebody has seen one of these red flags and they're concerned about something around them and they want to come forward and share information with you through the whistleblower programs or otherwise, like what's the best vehicles, if you will, for them to go and do that, or the best places for them to go?
Yeah, so there's a landing spot on our webpage, which is justice.gov/ATR. For whistleblowers to report their submissions, we have a team that is reviewing those daily. There's a form where it asks for certain information, and that's the primary way to kind of get that put that whistleblower submission into us. But even if it doesn't qualify, even if your information doesn't qualify under the whistleblower program, we'd still like to report.
Yeah,
we have other reporting mechanisms there as well, depending upon what exactly it is you want to report. Yeah. The strike force that I had, we have a specific form to kind of ask for particular information. But all of these submissions are being monitored in real time by a team of professionals here, and we get back to folks as soon as possible. Failing that, pcsf@usdoj.gov is an easy way to get in touch with us.
We'll put the links to both of those in the show notes for today's episode. For anyone listening, this episode will be at artofprocurement.com/podcast. That's artofprocurement.com/podcast. You'll see this conversation along with all the other podcasts that we have, but you click through to that and you'll see the links that Daniel talked about. It's been a fascinating conversation, kind of into the world and the work that you do and the protections that you bring for the US government. I want to thank you so much for joining me today, Daniel.
Thank you so much. I really appreciate it. I had a great time. Thank you.
Thanks a lot.